my grandmama died.
I'm not going to allow you to continue to delay these matters.
Is also another violation of
No, you need to talk to me.
I didn't interrupt you when you speak. Extend me the same courtesy. Okay? I was trying to.
Are you almost done?
Yes, to take us out.
You did it again. The caption you just changed.
May I show this to you?
No.
This.
You did the same thing. Who filed this dismissal?
We did. I did.
You're not the plaintiff.
I'm a counterplaintiff.
Then how do you give me a notice of dismissal regarding this case?
That was
and not sign it.
This woman has returned to court for the third time, and once again the same issues remain unresolved despite clear instructions from Judge Simpson to correct her paperwork and secure proper legal representation. She arrived with the same deficiencies and even more complications added to the file. At this stage, it no longer appears to be confusion, but rather a refusal to follow direct guidance from the court. The landlord's attorney continues to appear prepared and organized while she approaches. Each hearing, as if attendance and compliance are optional, the contrast between preparation and repeated neglect is becoming more obvious with every appearance. Walking back into court under the same circumstances would be uncomfortable for most people, yet she proceeds without visible adjustment. Now the focus turns to how Judge Simpson will respond to this continued pattern and whether the court's patience has finally reached its limit.
Your Honor, plaintiff, Anthony, but may not appearing on behalf of plaintiff.
Good afternoon, Your Honor. Azar Stafford.
Your interpretation in this case.
Your Honor, I'm not quite sure. Last time we appeared in the court had advised parties to reserve all the documents that had been served because of some last pleadings the defendant filed. I haven't received any additional pleadings from them. We did file an answer to those pleadings. I do notice that I pulled the docket today, and there is, as of today, some reference to a dismissal with prejudice. I'm not quite sure what that would mean in this instance.
The problem is, and you've not received any documents that you attempted.
Nothing since the original delivery that I placed on the record.
At the last hearing, I struck all of the documents that had been filed by the defendant in this case because she had changed the caption. They were to be refiled and served.
They were not.
Was that done?
Yes,
Was that done?
Your Honor, first of all, we have not been.
Ma'am, I asked a yes or no question.
Yes, Your Honor. We served the plaintiff with the joinder we filed and in federal court. We did. The plaintiff did not send us any pleadings. I have not received any complaint. I have not received. He has not followed the rule 5.108 of 7-day notice that he has to give me. He is in violation of professional responsibility, Rule 7 and 8. We have not received any complaint, or he cannot produce proof of service to us, Your Honor. But we can provide proof of service that he was served by sheriff for federal claim.
Let's try this again. The last time that you were here, I told you that you had improperly changed the caption on the pleading. I struck those pleadings, told you that you needed to refile them with the correct caption and serve them on opposing counsel.
Yes, we did.
My sole question to you is, did you do that?
Yes, Your Honor.
Did we get a new filing? Yeah, because if she filed them and served them, they would be in my court file. And it's odd. I don't see new filings in my court. And I don't see, and counsel's indicating he didn't get it, but she's telling me she didn't.
JIS today and answer a motion to dismiss this file?
That was...
Not by me, Your Honor.
Yes. Okay, I see that. But that was not the original.
I have not seen that.
I still have Carl Staffield on this case, and I don't know why.
Because he's a resident too.
Then he needs to properly join the case. I don't. You did it again. The caption you just changed.
May I speak, Your Honor?
Yeah, go ahead.
Okay.
We did the same thing we did the last time.
May I show this to you?
No.
This.
You did the same thing.
No. This notice to appear is only addressed by the plaintiff for my daughter only, who is out of town, and we received it in the mail yesterday. And it doesn't even have my name on it.
Who filed this dismissal?
We did, I did.
You're not the plaintiff.
I'm a counter plaintiff.
Then how do you give me a notice of dismissal regarding this case
That was
and not sign it?
I'm sorry.
You filed a dismissal of the case under the section notice of dismissal by plaintiff. You are not the plaintiff.
I am a counter plaintiff, Your Honor.
In her latest filing, she submitted a motion for dismissal as if she were the plaintiff, even though she is the defendant in an eviction case. That is not a strategic legal tactic, but a clear misunderstanding of her actual role in the proceedings. After 3 separate hearings, this type of mistake raises serious concerns about whether she is paying attention to the structure of the case. By now, the court has explained the basics more than once, and the distinction between plaintiff and defendant should be unmistakable. At this point, it feels less like confusion and more like a refusal to approach the matter with the seriousness it demands. When someone continues to ignore clear direction, the court is left with limited options moving forward.
I'm not accepting any of these pleadings until you get the caption. I'm not accepting these sort of random documents coming in as a dismissal, a notice of dismissal. The only thing that you would be entitled to dismiss would be to the extent you believe you have a counterclaim. That's the only thing you're going to dismiss. You can't dismiss his claim.
Yes, Your Honor. My grandmama died, and we are flying out of US next week to attend the funeral. If you want to...
I'm not going to allow you to continue to delay these matters through some improper procedures that you're employing. I'm not going to let that happen. My condolences on your loss, but I am not going to just continue to lay this matter out to have you continue to do the same thing.
What am I doing wrong, Your Honor?
I have already told you what you're doing wrong. If you don't think you're doing anything wrong, then maybe you need to get an attorney.
When she asked what she was doing wrong after the judge had already explained it several times, the moment felt almost unbelievable. That reaction did not reflect someone making a genuine effort, but rather someone repeating the same pattern without absorbing the guidance given. The court had outlined the corrections clearly and more than once, yet she continued to act as though the instructions were brand new. It creates the impression that she may be delaying in hopes that persistence alone will change the outcome. In situations like this, seeking professional legal help would likely be the most practical step forward. At some point, pride has to give way to practicality, especially when the stakes involve housing and court orders.
That's licensed to practice
Yes.
to do this.
Okay. Could we have next hearing after April 1st, please?
I'm not going out that.
Your Honor, this is the 3rd appearance in this case.
Oh, I know.
You gave her 2 weeks after the last,
To get everything right, and
and you admonished her to get an attorney at that point.
I did.
Yes.
Striking those pleadings. Don't file anything else that's improper and not properly filed. Just going to be that direct.
Okay.
Matter will adjourn to March 21st, 2020.
If I may, Your Honor, briefly, just briefly, this is not a rent case, Your Honor. This is
Oh,
a
I know.
termination of tenancy. The lease has been up for 60 days. She's staying in there. There was an escrow order that was filed. To our knowledge, she hasn't paid the rent. To our knowledge, she didn't pay the jury fee. To our knowledge, all these things have happened, and my client is being prejudiced by the moment here. There's damage occurring to the premises. There was construction and landscaping that was violative of the city ordinances and the HOA standards. We have a witness here today to testify that the property is being damaged as we speak. And we need,
What way?
there's significant runoff and sediment runoff that the backfill was backfilled 4 feet to 5 feet to more over the base of the trees in the backyard. And that's been that way for some time. The fact of the matter is she's had more than, I'm defer to the court, of course, but she's had more than she's filed this federal suit. She's doing everything possible to delay our occupancy. And I just don't think it's equitable or right. It's of course your decision, Judge.
Oh, I know.
She knows well what she's doing to buy time here. And she served all these pleadings. She claims she doesn't have an attorney. I read the pleadings. They were drafted by somebody other than her, it appears. She hasn't followed one rule. She hasn't served me once correctly. The person that's named in the incorrect caption isn't even a tenant on the lease. I don't know where they came from here, but they're non-party. My clients had to pay me to come in here and deal with all this sort of thing. And they've joined us in a federal case that names almost verbatim the same cause of action that's named in this very counterclaim that the court struck and apparently dismissed with prejudice. All I would ask the court is that I possibly could get if she wants to appeal this, and I would pretty much bet she's going to when the time comes. Let's get that process started if at all the court would go along with us. Let's get a judgment for possession entered. We can give them a little extra time if they want to put in the appeal period and get us our judgment, and then she can do what she's going to do anyway when she gets her day in court. According to her, she's been here 3 times. I've traveled from Oakland County.
I'm sorry to hear that.
3 different, yeah, me too. 3 different times to be here, Judge. None of what she files makes any sense. And it's just not right on my client's behalf to let my client continue to suffer while they occupy the premises without any consideration. She's going to appeal this if we win, and we probably will. The point being, let her appeal. Let's get that process started if that's what she's going to do. Thank you, Judge, for listening. Yes.
Okay, good.
I want to answer.
Go ahead.
Your client, sir.
No, you will address me.
Okay, I apologize. This client, Your Honor, is a loan shark who bought our property in a redemption period and signed an agreement to let us buy this house back from him. We are ready to go ahead buy this house back, but while his client was owning this place in last 9 months, the Barton Village put a lien on the property. Now we cannot get a mortgage because they have a lien on the property. And what by him in this court trying to put me down because I'm representing myself is also another violation of
No, you need to talk to me.
Referring to the buyer as a loan shark after losing the home and remaining beyond the lease period is an extreme reaction. Consequences that follow missed payments and expired agreements are not personal attacks, but the direct result of prior choices. Purchasing property during a foreclosure redemption period and then expressing shock over existing liens reflects a failure to research and understand the transaction. Liens are legal claims tied to property and they do not appear without documentation or notice. What we are seeing is not victimization but a series of decisions that were made without careful review. When obligations are ignored and timelines are missed, the legal and financial outcomes that follow are predictable rather than unfair.
Yes. Your Honor, we have served everything. This gentleman cannot provide one proof of service to this court. He gives us papers last minute. We received this in the mail yesterday. He did not serve us properly.
That was the escrow order only.
Okay. I'm sorry. Please don't interrupt me. Thank you very much. I didn't interrupt you when you speak. Extend me the same courtesy, okay? This loan shark and his attorney are trying to...
Are you almost done?
Yes, to take us out of our home. And they put a lien on that house. So now we can't even get a loan to purchase the mortgage to purchase the property because it has a loan. Now he's asking us for the possession. We paid the rent, but the rental agreement is over. We want to buy the house. The lien doesn't let us buy the house, Your Honor.
I would ask for one brief moment to respond to that, if the court wishes.
Why are we doing this? Okay, so here's what happened. I told you what I was going to do.
Enough said.
You wanted to talk, then you wanted to respond. And now you want to go back and guys want to spend all day going back and forth. Tell you what, we can put you over there on the side. I can handle all these other people's cases so they don't have to sit through this. I'm required to. And you guys can just go back and forth and then I'm going to do what I was going to do 5 minutes.
This is exactly why many people respect Judge Simpson. When he told them they could continue arguing in the corner while he moved forward, he was not joking but signaling that the court would not be delayed any longer. That statement reflected efficiency, not sarcasm, and it showed that his patience had limits, that a courtroom is not a debate club where endless back and forth is allowed without direction. There is a structure in place to ensure fairness and order, and that structure applies to everyone who steps inside. When someone repeatedly ignores that framework, the judge is left with no choice but to proceed without entertaining further disruption.
Hearing nothing else, March 21st, 2025, 2 p.m. You get the pleadings right or get an attorney in. Thank you.
Thank you, Judge.
Ma'am, you're not going to yell when you're in here. You're not going to whisper under your voice. I don't operate that way. Understood? No. Understood. I heard you all the way up here. Have a great weekend.
Thank you, Judge.
Can do me a favor, can you go out there and just make sure they don't
In many ways, this situation appears to be driven by pride combined with stubbornness rather than careful judgment. Choosing to represent yourself in a complex legal matter does not automatically signal courage and often leads to costly mistakes that could have been avoided. Judge Simpson extended opportunities and patience that not every defendant receives, yet those chances were met with the same repeated errors. When clear warnings are given early, the wisest response is usually to adjust course and seek qualified legal guidance. Standing on principle can feel empowering, but when it results in weakening your own case, the outcome becomes self-inflicted. Courts respond to preparation and compliance, not to personal pride or resistance to advice. That brings this hearing to a close, and it serves as a reminder that accountability shapes every legal outcome. Thank you for following along, and stay tuned for more in-depth coverage of courtroom proceedings.